Good morning, everyone. I call to order the June 8th, 2021 Administrative Regulation Review Subcommittee meeting. First off, thank everyone for being here, and those that are joining us today by way of Zoom, please keep your phones muted until you're ready to speak, and then if you want to speak, then you can unmute and we will take your question. But at this time, I'm going to have the Secretary please call the roll at this time.
Senator Rocky Adams.
I am here, but virtually from the district.
Thank you. Senator Kerr. Senator Yates. Representative Bridges. Thank you. Representative Frazier.
Present at home and district.
Thank you. Representative Marzian. Co-Chair West.
Present in the room.
Thank you. Co-Chair Hill.
Present in the room.
We have a quorum.
Thank you very much. We do have some of our members not able to be with us today. That's always something that happens during June and July, but we do have a quorum today. And a quorum being present, this subcommittee is duly constituted to do business. The first matter of business today is the approval of the minutes of the last meeting. Are there any additions or corrections to the previous meeting of last month? There being no questions, is there a motion for approval?
Motion.
There is a motion.
Second.
And there is a second. Without objection, it is so ordered. At this time, please call the first regulation today.
Under Finance and Administration Cabinet, Department of Revenue, 103 KAR 26-131. This has a staff suggested amendment.
This regulation establishes the interpretation of how sales and use tax laws apply to landscaping companies. The staff suggested amendment amends various sections to comply with the drafting requirements of KRS Chapter 13A and make technical changes.
Thank you. Whoever is joining us today from the Finance Administration Cabinet, would you please identify yourself for the record at this time?
Good morning. I'm Bethany Atkins Rice, legal counsel for the Finance Administration Cabinet's Department of Revenue.
And good morning. My name is Richard Dobson. I'm the Executive Director of the Office of Sales and Excise Taxes at the Department of Revenue.
Thank you very much, Mr. Dobson. Ms. Rice, welcome this morning. There is a staff amendment to this regulation. Is there a motion for approval of this staff amendment?
Motion.
There is a motion. Is there a second? There is a second. Without objection, it is so ordered. Are there any questions from any of the members, or would either one of you like to comment at this time? Or are you just ready for any questions we may have?
We're available for, Mr. Chairman, we're available for questions. Be glad to entertain any. This is a regulation that really relates back to legislation back in 2018. We talked with the stakeholders, engaged with the landscapers, the CPA Society, and so forth. So we've provided the needed guidance based upon input from the business community.
Thank you very much for those comments. Are there any questions from any of the members here present or any online? It appears there are no questions. We thank you all for your time this morning. We appreciate it very much. Seeing no questions, please call the next regulation.
Board of Pharmacy, 201 KAR 2040, 171, 205, and 390, all with staff suggested amendments.
201 KR 2040 amends to remove the passport photograph requirement for the application for registration as a pharmacist intern and update material incorporated by reference. 201 KR 2171 establishes standards for computerized record keeping. 201 KR 205 amends to delete language in the definition of pharmacist in charge relating to out-of-state pharmacy permits and update material incorporated by reference, including for consistency with 201 KR 2050 that had previously increased the initial application fee from $100 to $125. 201 KR 2390 amends to conform third-party logistic provider licensing requirements to federal law and update material incorporated by reference. The staff amendments for these regulations all amend various sections to comply with KRS Chapter 13A. Additionally, the staff amendment for 201 KR 2390 amends Section 1 to add definitions of board, illegitimate product, and third-party logistics provider.
Thank you very much, Carrie, for those explanations. Whomever is joining us again today, would you please identify yourself for the record at this time?
Yes, thank you. I am Larry Hadley, Executive Director, Board of Pharmacy.
And Eden Davis, General Counsel for the Board of Pharmacy.
Ms. Davis, Mr. Hadley, thank you this morning for taking time to join us this morning. There are staff amendments to these regulations at this time. Is there a motion for approval of these staff amendments?
Motion.
There is a motion. Is there a second? There is a second. Without objection, it is so ordered. Would either of you have any comments, or would you just entertain questions?
We would be happy to entertain questions.
Are there any questions from any of the members present today or joining us remotely? It appears, sir and ma'am, there are no questions today. We thank you for your time, and we appreciate you being with us today. Please call the next regulation.
Thank you.
Board of Nursing, 201 KAR 2506. There are not additional amendments to this regulation.
201 KR 2506 amends to update the date for the Interstate Commission of Nurse Licensure Compact Administrators' final rules from January 2019 to 2021, the website at which the materials can be found, and the material incorporated by reference.
Would you please identify yourself today, whomever's joining us from the Board of Nursing?
Good morning, Kelly Jenkins. I'm the Executive Director.
Good morning, Jeff Prather. I'm General Counsel.
Thank both of you this morning for being with us. There are no amendments. Are there any questions from members of the subcommittee to either one of our guests joining us today? It appears that you've gotten off easy today, so we do thank you again for your time. There being no questions, please call the next regulation at this time.
Thank you.
Thank you.
You're welcome.
Board of Alcohol and Drug Counselors, 201 KAR 35010 Emergency, 020 Emergency, both with staff suggested amendments, 025 Emergency, 040 Emergency, 050 Emergency, 055 Emergency, 070 Emergency, 075 Emergency, and 080 Emergency.
This package of emergency administrative regulations all amend to make changes to comply with Senate Bill 191 from the 2021 regular session that added the two credentials Certified Alcohol and Drug Counselor Associate 1 and Certified Alcohol and Drug Counselor Associate 2. Additionally, 201 KR 35010E amends to include under applicant an individual who has applied for temporary registration or temporary certification, and change the number of board members needed for a complaint committee from 2 to 3. 201 KR 35020E, consistent with recent legislation, establishes various fees for renewal, late renewal, and reactivation. 201 KR 35040E amends to allow live synchronous continuing education presentations to count as in-person trainings. 201 KR 35055E through 35080E amend requirements for licensees to reduce from 2 years to 1 year the requirement for recovery by an applicant, streamline information for educational transcripts and billing, establish that temporary certification shall be for 2 years, increase extension opportunities, delete the 300-hour requirement for clinical supervisions, restructure, clarify, and update supervision requirements, clarify and revise requirements for inactive and retired status, and update material incorporated by reference. The emergency amended after comments regulations for this package all amend to make changes to comply with Senate Bill 166 from the 2021 regular session by adding in the credentials of a licensed alcohol and drug counselor and provisions for clinical supervisors. The amended after comments versions make clarifications, technical corrections, and update material incorporated by reference. Additionally, the amended after comments versions for 010 and 020 include a certified alcohol and drug counselor degreed. The emergency regulations for 201KR 35025E through 080E are all okay without further amendment. The staff amendments for 201KR 35010E and 020E both amend to delete references to certified alcohol and drug counselor degreed to comply with statutory authority.
Thank you very much. That was a lot. That was a lot. Would you please identify yourself today, whomever may be joining us at this time from the board?
Yes, sir. Kevin Winstead. I'm the contact person for these regulations. I'm the acting commissioner with the Department of Professional Licensing, which provides administrative services to the board. And I'm accompanied by
Tim Cesario. I'm the chairman of the Kentucky Board of Alcohol and Drug Counselors.
Gentlemen, thank you both this morning. Before I proceed, let me just say thank you all for what you do. We certainly know that there's a lot of challenges. We have a lot of problems across not only Kentucky but across the nation with these issues. And I certainly want to commend you, gentlemen, and all of those that work in your department for the efforts that you put forth. We personally, I want to say thank you very much for that today. There are staff amendments to these regulations that was presented to us. Is there a motion for approval of the staff amendments?
Motion.
There is a motion. There is a second. Without objection, it is so ordered. Are there any questions from any of the members of the subcommittee, or would either of you gentlemen have any comments you'd like to make?
I don't believe we have any particular comments, but certainly welcome questions.
The only question that I would have, and this is certainly, I hope that no one takes this in the wrong manner. We on this committee, we face a lot of regulations that come to us each month that are attached with an emergency, and I see these all are emergency regulations. Could you, and again, I don't mean to put anybody on the spot, but again, we have a lot of emergency regulations that we deal with, and there's always a little bit of a question comes to our mind. What's the reason for that emergency immediately? And I think I know the answer to that, but would you just care to explain that just real quickly, if you don't mind, sir?
Yes, sir. Yes. So these were filed as emergency regulations in early March with matching ordinary regulations, which are also going through the promulgation process. But for the emergency regulations, two reasons. The first that I'd like to mention is that there was a bill last year, Senate Bill 191, that created two new credentials that took effect on March 1 of this year. And then further, in late March of this year, the legislature passed Senate Bill 166, which created two additional credentials that were also effective March 1 of this year. And so at the time these regulations were filed, they were filed to meet that imminent deadline of two new credentials in order to provide the way for them, for people that wanted those credentials to apply and to comply with the regulations. In addition, there's the public safety, health and welfare was involved because there's a shortage of the qualified counselors available in this area to treat the individuals that need services.
Yes, sir. Thank you. I certainly agree with that, and I appreciate that explanation. As I actually really dug into these regulations yesterday and read all of them, and I just wanted to get an explanation for myself and the committee as to why that there was the emergency attached to them. But I think you certainly answered the reason for that is we certainly have a great need. And again, I just want to say thank you for what you all do and your efforts in that. Does anybody else on the committee have a question or comment? Anyone remotely have anything? Thank you, gentlemen, again for your time today. There being no questions, we appreciate you being with us. Please call the next regulation.
Thank you.
Mr. Chairman,
Yes.
this is Alice Kerr, and I am present. Had a
Yes.
little trouble getting the link. Thank you.
Thank you, Senator Kerr. We're glad that you were able to join us today.
Thank you.
Are you remotely or from your office?
I am from my district.
From your district. Welcome from the district
of District 12.
Now, that's not normally, Miss Kerr, what you say.
No, I'm here in Lexington, Kentucky, where everybody is somebody, where everybody is loved for what they are, and where nobody is a stranger.
Thank you. I hadn't heard that for a while. I just wanted to hear that this morning. So
you can use it up there in with your church if you want.
We better get back to business, I guess, at this time. But we do thank you, Senator. Glad you could join us today. Please call the next regulation at this time.
Energy and Environment Cabinet, Department for Environmental Protection, Division of Waste Management, 401 KAR 39060. There are not additional amendments.
401 39060 amends requirements for waste that generates, treat, store, recycle, and dispose of hazardous waste to add Bluegrass Army Depot codes for the treatment and disposal of specific nerve agent munitions.
Whomever is joining us today, would you please identify yourself for the record at this time?
Good morning, Chairman Hale and Co-Chairman West and members of the committee. My name is Tony Hatton. I'm Commissioner of the Department for Environmental Protection.
Thank you, Mr. Hatton. We're glad to have you with us today at our meeting.
Good to be here.
There being no amendments to this regulation, are there any questions from members or from any of the members of the subcommittee concerning this reg? Senator West has a question. Proceed, Senator West.
Thank you, sir. Just the mere subject line of this regulation, it might be good for the general public watching if we could explain what is actually happening here.
Senator West, I'd be happy to do that. So I'll provide some context and backdrop, and then we can drill down. I'll be brief. We can drill down to exactly what we're trying to accomplish this proposed regulation. But chemical munitions, particularly those that are stored at the Bluegrass Army Depot, consist of what are commonly known, or what are commonly termed as GB, VX, and H, which is a mustard. And they are there in several different formats: rockets, warheads, so on and so forth. They have been stored over there for a considerable period of time, and about 2% of the nation's stockpile exists at Bluegrass Army Depot. These are hazardous waste under Kentucky law. They're not hazardous waste under federal law, but they are under Kentucky law and KRS 224, Chapter 50. And the reason they're hazardous waste, and particularly a subset of acute hazardous waste, is because of their toxicity. They are a nerve agent, and the way in which they function, they disrupt your nervous system's ability to communicate with your organs. That's why they cause the health effects that they do. Obviously, they're very dangerous. And because they are a hazardous waste by law, they are included in our regulations, particularly Chapter 39, where they are specifically listed out what these particular wastes are and what the responsibility of the Army is to treat, store, and dispose of them. They have to be treated to what is commonly referred to as 6 nines, which means the removal efficiency as they're treating and demilitarizing these munitions. The removal efficiency has to be 99.9999% effective. The statute that I referred to, Chapter 50, envisioned from early on that as they began to treat these munitions, there would be certain secondary wastes that would be generated. And under standard hazardous waste laws, if a waste contains a listed hazardous waste, any treatment residues from that are also listed hazardous waste. In this particular case, they'd be acute hazardous waste. So what we are seeking to accomplish here, and we believe it's a good and proper thing to do, is that recently the Army has moved away from their original treatment process of neutralization. And the reason they have done that is because the neutralization process created more potential danger and exposure to workers because they would be spending more time around the munitions for longer periods of time. They have recently altered their process to static detonation, and my agency is responsible for overseeing everything they do and permitting everything they do. Well, as a result of the static detonation process, there are additional waste streams that are going to be generated that weren't originally envisioned. And what this regulation amendment seeks to do is, because those waste streams, those secondary waste streams, have been treated to 6 nines, is to not manage them as a hazardous waste, but to no further manage them as an acute hazardous waste. And what that will ultimately result in is a simplified process for managing these wastes and moving them to disposal locations more quickly without compromising any public health or safety issues. A second thing that it will accomplish as these wastes are being transported with these particular codes that we're looking at adding into the regulation, anyone who might be involved in a transportation issue or accident will know precisely what the contents are in the containers that may or may not have been compromised. So that's sort of setting it in context in a nutshell. I can tell you that they are continuing to actively demilitarize over at Bluegrass Army Depot. And we're all hopeful that we get to the 2023 timeframe, that a good majority of the munitions that have been stored there will have been demilitarized and be in a much safer position or condition. So I trust that's a little bit of a context and background from which you all may have more questions.
Yeah, thank you so much. I knew there would be a very complicated answer to that question, and
my apologies, sir, if I overcomplicated.
No, it's great. I appreciate that. It does help, the general public to understand what's going on. So I appreciate that. Thank you.
Yeah, you're welcome, Senator West.
Thank you, Senator West. Sir, did I understand in your explanation there that is this process projected to be completed approximately 2023?
Barring no unforeseen issues related to disposal options or funding changes in funding, that is the plan. And the Army's certainly moving towards that. We work with them daily. As a matter of fact, within my department, we have a group of people that are that's all they do is work on this project and permitting issues with it. We have inspections. We have inspectors out there 24/7 during the whole process. I get 4 or 5 reports a day, so they're overseeing every step of the process.
Well, I know it's been a huge undertaking over the past few years, and
yes.
It was certainly something that needed to be done with those being stored right here in the middle of our state, and I'm certainly glad to see that process. I was glad to see the process begin, and I certainly look forward to that process ending in a couple of years. But we do thank you for your time. Are there any other questions from any of the members? There being no questions, again, thank you, sir. I'm sorry, is there?
Sorry, this is Representative Frazier.
Yes,
I just wanted to express to him that as one of the representatives of Madison County, we're very appreciative of the work that they're doing and how they have progressed and all along keeping the safety of the citizens in mind. And they do great work, and I just appreciate it.
Thank you, Representative Frazier.
Thank you, Representative Frazier, for your comment. And again, if any of the members have questions, just feel free to jump in, and I'll try to recognize you as quickly as possible. Thank you again, sir, for being with us this morning. We appreciate your time. There being no further questions, please call the next regulation.
Transportation Cabinet, Department of Vehicle Regulation, 601 KAR 1005. This does not have additional amendments. 601 KAR 231 and 233 emergency. Neither of these have additional amendments.
601-1005 is being amended to implement the requirements of KRS 174-410 to carry out the intent of KRS 174-400 through 174-425 relating to the transportation of hazardous materials by air or highway, and incorporate by reference the Federal Hazardous Materials Transportation Regulations.
601-2231 repeals requirements for ignition interlock devices from prior programs. 601-2233E establishes requirements for the Kentucky Ignition Interlock Program as revised through 2020 legislative changes.
Would you please identify yourself this morning, whoever is joining us from the Transportation Cabinet, please?
John Johnson, Assistant General Counsel, and I have also with me Staff Attorney Larissa Plecha, Jason Sawula, and I'm going through this list here. I may leave some folks out. Captain Truesdale, Tom McDaniel, Mary Cook, and Tiffany Duvall. I believe I have everyone.
All right. You have quite a contingent with you today, sir.
We came prepared.
You came prepared. There are no amendments to these regulations. Are there any questions for any of the individuals that's joining us today on these regs? It appears, sir, that there are no questions from any of the committee members, but we do thank you and all of those that joined you today. Appreciate that so very much. Thank you for your time today. Having no further questions, thank you, sir. Please call the next regulation.
Thank you.
Thank you.
810 Public Protection Cabinet Horse Racing Commission. 810 KAR 2001 Emergency. Chapter 3001 Emergency, Chapter 4001 Emergency, Chapter 5001 Emergency, 810 KAR 5080 with staff suggested amendment, 810 KAR 6001 Emergency, 6010 Emergency, 6030 Emergency, 810 KAR 8010 with staff suggested amendment, 810 KAR 8020, 810 KAR 8025 with an agency amendment and a staff suggested amendment, 810 KAR 8030 and 8040 both with staff suggested amendments, and 811 KAR 251 emergency.
810 2001E, 3001E, 4001E, and 5001E revised definitions. 810 5080 amends requirements related to races of the Kentucky Proud Series to restructure fees. The staff suggested amendment amends various sections to comply with KRS Chapter 13A. 810-6001E revises definitions. 810-6010E revises procedures for exotic wagering. 810-6030E revises requirements for parimutuel wagering. 811-1251E repeals 811-1250 exotic wagering because the requirements have been established in 810-6030.
810-8010 through 040 update the Commission's medication guidelines, including prohibiting the use of clenbuterol except under specified conditions and adding material to the body of the regulations that was previously incorporated by reference. The staff suggested amendment amend various sections to insert existing text that was inadvertently omitted and to comply with 13A requirements. The agency amendment for 025 amends Section 14 to add administration specifications for clenbuterol in accordance with 810 KAR 8010.
Good morning. Would each of you there at the table today please identify yourself, and we'll start with you, ma'am. I believe, could you please you need to move your mic over a little closer if you don't mind, and push the button there until the green light comes on.
Sir, can you hear me now?
Yes, ma'am.
Thank you very much. My name is Jennifer Wolsing. I'm the General Counsel for the Kentucky Horse Racing Commission.
My name is Wakas Ahmed. I'm the Director of Parimutuel Wagering and Compliance.
Mark Guilfoyle, Executive Director, Kentucky Horse Racing Commission.
Will the other two folks be speaking? Could you please identify yourself?
Jamie Eads, Deputy Executive Director for the Kentucky Horse Racing Commission.
Thank you.
Chad Thompson, Deputy General Counsel for the Kentucky Horse Racing Commission.
I'm Dr. Bruce Howard. I'm the Equine Medical Director for the Kentucky Horse Racing Commission.
Thank each of you this morning for joining us at our meeting. Would all six of you please raise your right hand at this time? And everybody that's going to be possibly speaking. Do each one of you affirm or solemnly swear that the testimony or the answers that you will give to this committee today are true, so help you God?
I do.
Thank you very much. There are staff amendments to these regulations today. Is there a motion for approval of the staff amendments?
Motion.
There is a motion for approval of the staff amendments. Is there a second? And there is a second without objection. It is so ordered. There is also an agency amendment that is attached today. Is there any discussion on that agency amendment from anyone? Would any of you like to address that agency amendment?
Sir, if there are any questions, I believe that we would be happy to take those questions.
Okay.
However, we do not have a prepared statement on it.
Okay, that's fine. Is there a motion for approval of this agency amendment?
Motion.
There is a motion. Is there a second? There is a motion and a second without objection. It is so ordered. Well, I'm going to begin. Certainly, the regulations that are before us today, again, this issue, not all of the regulations, but there has been some very contentious moments in the legislature in this last session concerning some of the legislation that was brought before us. And we have attached here today, again, emergencies attached to each one of these regulations. To my knowledge, I think they all have emergencies. Maybe there's the medical 810, 088, 010 does not. 02 does not. Am I correct on that?
Also, 810-5080 does not.
Okay. But of the ones that do have the emergencies attached to them, again, this committee, we always get nervous when we see emergencies attached to the regulations. It's something that we have been dealing with since I've been on this committee, and it has always, I think, caused, I won't use the word a problem, but I think that it has caused us a little apprehension at times when we see emergency attached to specific regulations. I know there was a comment period that was set up for public comments. Were there any individuals that showed up at that comment period?
Yes, we did receive written comments from the Family Foundation regarding our parimutuel wagering regulations. Of note, the parimutuel wagering regulations are the only ones that have an emergency tag appended to them. The medication regulations, as well as the regulation regarding the Kentucky Proud Series 5080, do not have any emergent tags attached to them. And we did provide a statement of consideration to the written comments that were received from Kent Ostrander, who is the Executive Director of the Family Foundation.
Was Mr. Ostrander given the opportunity to speak in person, or were just written comments?
Sir, everyone was given the opportunity to attend a public hearing. We actually would have conducted it by Zoom. However, we did not receive any notes of anyone who actually wanted to attend the hearing. So at the appropriate time, we went ahead and canceled the public hearing, and we simply took the written comments instead.
So again, Mr. Ostrander did not ask to appear in person?
That is my understanding, yes, sir.
Okay. Again, we look at this in this specific reg dealing with the parimutuel wagering, and could you give me an explanation, or anyone at the table, as to the reason that there has been an emergency attached to that?
Yes, Representative, we'd be happy to do so. Primarily on February 11th, 2021, the Kentucky General Assembly passed Senate Bill 120, which enacted several changes to parimutuel wagering in Kentucky, primarily as it related to historical horse racing. Those changes included definitional changes to terms such as parimutuel wagering and licensed premises, and these emergency regulations were filed to ensure compliance with Senate Bill 120. If our regulatory and statutory definitions did not match, then the Racing Commission would not be able to regulate live or historical horse racing, as the statutory definition would supersede any conflicting regulatory definition and render the latter ineffective. In addition, the Commission began migrating its regulations from Title 811 on September 9th, 2020, due to KRS 13A.2102, which states that regulation sunsets 7 years after the regulation's last effective date, except as provided by a certain certification process. Due to the Kentucky Supreme Court's opinion in the Family Trust Foundation case, as well as the passage of Senate Bill 120, the parimutuel wagering regulations that we were attempting to migrate became obsolete. Therefore, the migration had to then take place via the emergency regulations, or the pending obsolete regulations would expire. If those pending regulations expired, then live and historical parimutuel wagering would not be regulated. And since if we were not able to regulate parimutuel wagering, then it would lead to a direct loss of substantial state funds via lost tax revenue from the Racing Association, and in addition, numerous jobs in live and historical horse racing industries would be endangered or eliminated.
And certainly I'm not here this morning. We're not here to debate Senate Bill 120. That bill has been passed. It's been signed by the governor, as you said, and this is not the reason of this committee's. We're not going there. I'm not going there. I don't have to tell you, and you know this, all of you know this, I was a very outspoken opponent against that. And personally, I'm going to go on the record as being an outspoken opponent against this regulation today. Again, your definition still did not personally to me satisfy as to the exact reason. Is the reason the revenue loss that would not, the revenue that would not be collected for a certain period if this was not put into effect by an emergency measure today?
In brief, I say that would be correct. We're also mandated by statute to regulate parimutuel wagering in live and historical horse racing, and if we had regulations that were obsolete or conflicted with the statutory definition, we wouldn't be able to do that. So that would be one major concern, and then the other major concern would be the loss of revenue and the loss of jobs.
Would anybody else like to comment on that? Mr. Guilfoyle?
No, sir.
No, sir. Before I come back with a couple other things, are there any questions or comments from any of the members today? It appears that there aren't comments or questions from any of the remaining or the rest of the members of this committee. And I'm not going to beat this to death this morning. And you've gave a very good explanation, and I certainly appreciate that. I appreciate your time being here, each one of you today. Again, I would like to go on record here this morning as being opposed to this specific regulation because of the emergency clause added to it. I have not. It is not your answers have not satisfied me as to the exact reasoning for that, but I will not pursue it any farther. But I do want to state for the record again that I oppose this regulation. And so having said that, there being no further questions or comments, we thank all of you for your time this morning. We appreciate you being here with us. Thank you for being in person. I very much appreciate that for you being in person this morning, and we wish you the best. Thank you very much.
We appreciate your time.
Thank you, sir. Please call the next regulation.
Cabinet for Health and Family Services, Department for Public Health, 902 KAR 211 emergency. This has an agency amendment.
This administrative regulation establishes requirements for face coverings. The agency amendment amends to update provisions in compliance with the executive orders currently in place, including an exemption for a person who has received the final dose of a COVID-19 vaccine at least 14 days prior. deletion of outdated requirements, and addition of current face covering provisions for unvaccinated individuals, which include public transportation, school, healthcare, long-term care, correctional or homeless shelter settings, and those who are immunocompromised, those who are exhibiting symptoms of COVID-19, or those who have tested positive for COVID-19 in the prior 10 days.
Thank you very much. Whomever is joining us today, please, would you identify yourself for the record this morning?
Yes, sir. Hi, my name is Wesley Duke. I'm the General Counsel for the Cabinet for Health and Family Services this morning, and I have Miss Julie Brooks with me, and she can introduce herself.
Julie Brooks, Regulation Coordinator for the Department for Public Health.
Thank you both this morning for being with us. Certainly appreciate your time today. There are staff amendments. Or is there a motion for approval? I may have spoken out of turn there. So the committee will stand at ease just for a moment. My apologies, there is no staff amendments. There is an agency amendment. My apologies again. Is there any discussion on the agency amendment? There being no discussion, is there a motion for approval of the agency amendment?
Motion.
There is a motion. Is there a second? There has been a second without objection. It is so ordered. I think that we have some questions today, and I am going to begin with Senator West, and we will proceed on if there are other members. Please be prepared if you have questions, but we will begin by Senator West. Senator West, proceed, please.
Thank you, Mr. Chairman. This is a big deal, and I would like the Cabinet to kind of start us off. If you could, give us just a brief chronology, and what I mean by that is this reg that is in front of us today, is it filed to carry out the May executive order of the governor or a previous executive order?
Thank you, Senator. I'll take that question. And yes, you are correct. These amendments are to bring the regulation into compliance with the governor's May 13th, 2021 executive order. And that's its sole purpose of these amendments. That May 13th order was, as the committee may recall, was entered on the same day that the CDC changed their guidelines as to masking in regard to being vaccinated. And that order was in compliance with that. And therefore, to be consistent, we wanted our regulation to obviously fall in line with both of those two things. So that was the sole purpose of this amendment, is to bring all that into compliance with each other.
Okay. So this regulation, so I'm a little confused. The regulation that was filed was on a previous executive order. It was filed to a previous executive order, and then the executive order a new executive order came out, and so now we're doing an agency amendment to meet the latest executive order. Is that correct?
That is correct. And just to and obviously a little bit of history here, but I'm sure the committee is aware, the EREG for masking there's been a couple of ways. Well, since its original filing, I think at one time when there were changes as the COVID-19 pandemic, we did a withdrawal and a replace one time, and we've also amended the EREG to comply with the governor's orders as they have rolled out, as things have changed and CDC has issued new guidance. So there's been, I guess, a lot of action in regard to this. But here we are today on June 8th. The purpose of this amendment is to bring the reg into compliance with the May 13th order.
So the regulation, I just want to make sure I'm following correctly. So the regulation with the amendment is meant to go to the May executive order. Mm-hmm. Doesn't that order expire in a few days on the 12th?
Yes, that is correct. That order will expire on Friday, the 11th. It's my understanding at that time that there will be additional, in regard to masking in the future, I think there's going to be guidance in regard to certain vulnerable populations, be it healthcare settings, nursing homes, things of that nature. But it's my understanding that that order will expire on the 11th and that there will be action taken in regard to the regulation on that date as well that will follow along with that order's expiration and the changes thereof.
So these regs, if we allow them to move forward, will only cover 2 or 3 days, right? That's all we're talking about, right?
A very short period of time, a very small window, yes. But this is just to remain consistent with May 13th, the CDC, which also entered their orders that day. I'm sorry, not their orders. They dropped their guidance that day. So yes, this is a very small window that this applies to.
Okay, those comments. Thank you. I thought that was what was happening, but I wasn't sure. What's troubling to me in many ways is this seems to conflict with the governor's public statements. And I looked up the Courier Journal and the Herald Leader quotes, but I pulled a quote from the Herald Leader where the governor has stated publicly that we will return to 100% capacity for all venues and events in exactly 1 month on June 11th, and life will almost be back to normal. That day, the state will also rescind its mask mandate for everyone, including those who are unvaccinated, with the exceptions of places where people are the most vulnerable. So if I look at this regulation, it appears that is not in fact going to happen, that the mask mandate will continue after June 11th. Is that correct?
It's my understanding, Senator, that the regulation will not continue past the 11th, and that what will remain after that will be, just like you said, will be guidance in regard to these vulnerable populations. But on the 11th, that the regulation itself, like I said, this is just an amendment to cover, and it is kind of odd, this very small window, but I think it is consistent with what the governor has said and what his intent is to do based on my knowledge thereof.
That's fine. So here's the problem. So if we allow this to move forward, these regulations, even though the executive order is expiring, won't these regulations continue on past the 11th?
They will continue until the agency takes action to repeal them, and it is my understanding that action is contemplated in unison with the executive order expiring on Friday.
Okay. So when in researching this topic for today, we did have public comment on these regs. And it appears that 27 people appeared and spoke against the regulations. What were some of those concerns of those people, and did you change any of these regs to comport with the specific concerns of those 27 people?
Senator, I'm going to refer to Ms. Brooks on that. She's got a better knowledge of the actual comments, so I think she can answer that question better than I can.
Yeah. So we had just a handful of people speak at the public hearing. Most of them were, written comments that were submitted. And of those, the majority of those 27 people, it was the same string of comments. There were 9 questions that were submitted. And there was, like I said, a number of people submitted those same comments. A lot of them were concerns over, again, the legality of requiring the mask mandate, the actions of the department. There were some, again, there was that study that the CDC had done that was brought up again, and that's the study from the morbidity and mortality report their weekly report that said that 70% of people who tested positive claim they always wear a mask, but that report doesn't, just on the surface, when you dig into that report, it actually shows that those were people that had been had gone out to eat and had been in close proximity to other people. So it's a little misinterpretation there, but those are the primary concerns. There were some, again, about just not wanting to wear a mask, some people feeling that it violates their religious beliefs. Those were the primary areas that were brought up. We did not amend at the time that we received public comment and we're drafting the statement of consideration. There was still in 13A the prohibition against amending an emergency regulation when it's an emergency only. Obviously, that has changed through Senate Bill 2. So even though through the response in the statement of consideration, we did not make any amendments to the regulation. Once that was filed, we did do an amended after comment version because there was interim guidance, and that was increasing the capacity limit at venues and those sorts of things. So we made changes to the regulation to comply with that order. And then the agency amendment, as Wes has said, the agency amendment that we filed last week brings the regulation into compliance with the May executive order.
So are you stating that, I'm trying to follow. So are you saying you didn't have time to make the agency amendments to take into account the public comments? Is that why the public comments weren't accounted for?
Okay. It's not that they weren't accounted for. It's just, prior to Senate Bill 2 and the passage of that, there was the prohibition against amending an emergency only regulation, even when you received public comment on that regulation. So that's why in the statement of consideration, we said we were not amending the regulation based on the comments received, but between the statement of consideration document being finalized and I guess there was an agency amendment, so there was an amended after comment version of the regulation that was submitted. That was done in May, for this meeting. And then in the interim between the regulation being put on the agenda for this meeting and today's meeting, we did a further agency amendment.
Which accommodated the May 13th executive order and the May 13th CDC change in guidance.
But none of, if I'm following, but none of those agency amendments really address the concerns of the 27 who spoke during the public comment period.
That would be a fair assessment. The amended after comment version that was submitted was to address the change in the mask mandate from the executive orders.
Thank you. Mr. Chairman, I'm going to pause. I've got other questions, but I want to allow other members to have their chance.
Thank you, Senator West. Are there any other questions from any of the members, either present here in the room or from remote?
Representative Hale, this is Representative Frazier. I do have a couple of questions, if I may.
Yes, ma'am. Representative Frazier, you may proceed.
Thank you for being here today to answer our questions. And as already been stated, this has been something that's been ongoing and evolving and changing as the pandemic has as well. But it's my understanding that there was a request to have this deferred. And I was wondering if you could tell me why that was, and then what was the ultimate decision of going ahead and moving forward today?
Yes, I can address that. Yeah, we made the request to defer this because, as we have discussed, on Friday, on June 11th, the executive order will expire. And also on June 11th, it's the intention that the regulation that we are here talking about today will be repealed by the action of the agency, and that there will be, at that time, some guidance coming out in regard to specifically healthcare based on, and maybe the long-term care venues. So it was our position that due to the expiration of the executive order and the plan to repeal the regulation, that on Friday the 11th, as we have stated, that things were going to change, and that was our. And so we made that request. That request was denied, and we're here today to answer anyone's questions in regard to the process of how we got here today.
Thank you for that. May I have a follow-up?
Yes, please.
Question on a different topic. Okay. Yep. This is just in regards to due process, which is something that's very important to me. But is someone able to answer what section of this regulation outlines the appeals process for an individual or a business that's been cited for violating this regulation?
It's been my position in regard to this and we have informed anyone that has been cited under this that they can seek through their local health department the process through 13B and that exist in many of the healthcare actions that they take. And as far as who has availed themselves of that, I know it has happened. I don't know how many times, but we've always made that abundantly clear to anyone who has been cited, pursuant to this regulation.
Okay. So public health departments do have the ability to cite businesses for violating this regulation today?
They do have the ability to cite, and throughout this process of when the reg was first passed, there have been, based on my calculations, approximately 320 businesses that have been cited. Most of them, actually the large majority of them, have been the one single citation, which did not involve a fine or anything like that. It was a warning citation. It has been the message of public health to the health departments that in regard to masking, your first priority is to educate these businesses, to work with them on remedial measures, and to try to assist them with this. So while there have been fines levied, they are under $1,700 total for the entire period of time throughout the entire Commonwealth. So the priority here has been to try to work with businesses, try to talk to them, try to educate them, and I think that has happened. I think the evidence shows that.
That's all the questions I have for now, but I may have some later as well. Thank you, Chairman.
Thank you.
Thank you, Representative Frazier. Anyone else today have a question? If you're remotely, just speak up and I'll recognize you.
Can I ask a question?
Yes, ma'am. Go right ahead, Senator. Proceed.
Hi, thank you. Well, first of all, I think that the reason the governor picked June 11th is because it's my birthday and we're going to open up the whole state of Kentucky on my birthday. I just want to put that on the record. But second of all, I heard testimony that the agency amendments were pulled together in conjunction with Senate Bill 2. And I was hoping you could explain that to me again, how you use that as a guiding document.
I will certainly try. So prior to Senate Bill 2, we could not have made an amended after comment version on an emergency only regulation. So we were between the statement of consideration and I guess the filing of that document in April. Senate Bill 2 allows an agency now to make an amendment to an emergency only regulation based on the public comments received. So that's, the prior version of the mask regulation that we had last year, we did not amend. We actually ended up withdrawing it and refiling this version of the regulation. We did do the statement of consideration. Now we were able to make amendments to the regulation because of the passage of Senate Bill.
Okay. All right, great. Thank you.
You're welcome.
Thank you, Senator. Are there any other questions?
I have a few more, Mr. Chairman.
Before I go back to Senator West, he has a few more questions. As the chair of this committee meeting today, I had several questions, but myself and Senator West we combined our questions. And so instead of both of us asking basically the same questions, I'm just going to defer back to Senator West, and he has the questions that myself and him had together. So Senator West, go right ahead, sir.
Thank you, Mr. Chairman. Appreciate the opportunity. You had mentioned a 13B hearing. Citizens can avail themselves of a 13B hearing, and that's what you've been advising them to do. Where in the regulation does it say that they have the ability to do a 13B hearing with the health departments?
Senator, it's my recollection that is not spelled out specifically in there using that language 13B, but we have made it very clear that they have that. And like I said, that is probably not as clear as it should be, but we have made it clear in practice to let everyone know that they have that right.
But what if it's not in the regulation, then how do they have that right if it's not spelled out that that's the proper tribunal that they can go to? Is that not, if we're going to have laws, shouldn't they be written down, and shouldn't the people be able to see that?
Well, and we have taken the position that obviously the health departments in their day-to-day regulations of businesses, and they do have their conference proceeding, which is a 13B proceeding, and that this is an enforcement of a public health regulation, and that the two go hand in hand. Now, once again, I understand your point as to how clearly is it spelled out. I appreciate that, but once again, they have that process in their basic regulatory scheme as a regulatory agency.
So, getting back to where we started, and I didn't expect to be here during this point in the meeting, but are you saying that as of June 11th, that you're expecting to see that you will pull back on all mask mandates except for what? So will unvaccinated people be required to wear face masks? Will vaccinated people be required to wear face masks? What do you foresee coming the 11th?
Yes, Senator, and like I said, this is based on my understanding of what's going to happen. I expect that this regulation will be repealed, and that there will be new guidance. And what form it's going to take, is it going to be by regulation or is it going to be guidance? I am not sure about that, but it will focus on two specific environments, and that is a healthcare setting, and that is a long-term care setting. I mean, we directly focus toward those vulnerable populations, and that will be the extent of any mask requirements or mask guidance. And that's based on my understanding of what will happen. But this regulation that we're discussing here today will, in fact, there'll be agency action to withdraw it and repeal it and move forward on that very targeted environments.
Okay. So I had a series of questions. Many of my questions are based on the regulation that is before us, and so that's all I can really cover. So if let's just thinking about this, if that were not to happen, and this is, I want to believe you, I want to trust what you're saying, and we'll be back here next month, so we may see you again next month. But let's say that doesn't happen. Let's say that this does move forward, and this regulation is not repealed. Our businesses have to abide by these regulations. How are our businesses going to enforce these regs? So, for instance, if someone's coming up to the front of a store and they ask someone about their have you been vaccinated? Is that a violation of HIPAA? Is that a violation of federal statute, to your knowledge?
Well, Senator, I can answer that question two ways. One, I have no knowledge of anything that would occur that would lead to these regulations going past June 11th. So that being said, it's my position that in that hypothetical that you just proposed, if a business owner asks a patron about their vaccination status, that is not HIPAA, that the HIPAA does not apply there. Now, there is a myriad of other federal laws that in regard to discrimination against someone for medical conditions, disability, certain things like that. But as far as a HIPAA violation, that the HIPAA does not apply there. Now, like I said, there are other legal issues that could come up. But once again, I want to reiterate, I am aware of nothing that would or could happen that will prevent this regulation from being withdrawn on the 11th and new guidance being issued in regard to, like I said, healthcare, long-term care, that will happen in conjunction with the expiration of the executive order. Now, like I said, that's my knowledge, but as far as the hypothetical you just described, I don't think that's a HIPAA issue, but there are some definite other legal, some statutes that may come into play there.
Yeah, I think especially if you talk about employees of businesses, if you ask them about their personal vaccination records, I believe that could constitute a HIPAA violation if they refuse to answer and then the company takes action. I believe that could violate HIPAA and several federal statutes.
Well, and like I said, it was my understanding that your first hypothetical was about a patron. Now, in regard to an employee, once again, there's other wrinkles there too. But I think there's a lot of guidance out now from the from the Federal Labor Department in regard to that, and it is kind of a murky subject. There's no doubt about it. But once again, I just want to reiterate, I don't think that's going to come up because it's my understanding of what will happen on June 11th is that this regulation will no longer be in play.
So my next line of questioning was pertaining to business closure, and one of the penalties in this regulation is, if you go through all the steps and you don't comply as a business open to the public, that the health department in this regulation has the ability to close your doors. So if I'm hearing you correctly, after June 11th, that all goes away. There's no, to your knowledge, and I understand that I'm asking you to make a hypothetical. You can't, see what the reg's going to look like exactly, but in your opinion, that's what you're thinking most likely will happen, that those stiff, harsh penalties will not be there.
That is correct.
Okay.
Are there any other questions?
Representative, I have a question, if I may.
Yes, Representative Frazier, go right ahead, please.
So just in what we have heard as far as being compliant, going back to May, and the hypotheticals of new issue guidance coming possibly after the 11th, does it make sense that this is something that should just be deferred, and so we're not playing in different pools? That's just a question for the committee as well as the people at the table.
Well, I think Representative, asked your question. That's kind of that line of thinking that we took when we asked for a deferral of this. So we were kind of thinking, because there is such a small window of time. Now, obviously, that request was rejected, and I understand why. So, like I said, that was part of our thinking process when we made that request.
Thank you.
That's fine. I'll take it.
Senator West.
Thank you, Mr. Chair. I'd like to address Representative Frazier's question. In all fairness to the cabinet representative, that the cabinet asked for a deferral, and the chair, co-chair, and myself, we refused that ask. And the main reason, in my opinion, the reason I did not allow that is I wanted the information out to the general public. I wanted people to know what was going on with this regulation so our businesses could plan their business models and do everything like that, their liability policies and things of that nature. So that's the reason that we did not allow for the deferral. Now, at this time, the line of questioning went a little bit different way than I expected. So if it's the intent of the cabinet that they will be repealing or withdrawing this regulation, then I would go ahead and just ask them to go ahead and withdraw it today. Is the cabinet open to withdraw the regulation?
You know, Senator, and I appreciate your question, and I hate to not be able to give you an answer, but that's a question that I can't answer here today without reaching out to the Office of Cabinet Leadership and what they feel comfortable with. I'm just unable to give you a yes or no answer on that, and I apologize for that.
No, it's not your fault. If I could continue, Mr. Chairman.
Yes, please go right ahead.
Yeah, it's not. I totally understand. And then to sum up, basically what you're asking us to do as a committee is just trust us. You know, just trust us. This is what's going to happen. This is what we will feel will happen at the end of the week, and then moving forward. But all we can make a decision on and all we have in front of us is this regulation that is in front of us. If this moves forward, this will be in place with no guarantee of it being repealed or withdrawn. And so we've given the cabinet the opportunity to withdraw today. And they've chosen not to do that, which is fine. And so personally, I feel we're in a really bad place because the administration has not built up a level of trust with the legislature. And the legislature, I feel, made itself very clear on this topic during the session of what its intent was through Senate Bill 1, Senate Bill 2, House Bill 1, and HJR 77. HJR 77 specifically set out that this specific regulation and various others are null and void. So it was clear from our session that what we wanted to happen as it pertains to this specific regulations. We laid out a bunch of regulations pertaining to governor's executive orders that we kept in place. We felt were good, and they needed to be carried out, and were good executive orders. I'm just personally afraid that we're moving from a time as we come out of COVID where some of these regulations are less about health and more about control. And it's dangerous when the government starts using its power to influence very important individual private medical decisions. And so what I don't want to see is, you can take off that mask if you're vaccinated. Well, that's definitely an incentive to be vaccinated. And some people have made the conscious medical decision that this is an experimental vaccine, and we don't want to go that route right now. We want to see how things pan out. And that's their decision. That's their private, individual medical decision. So if it's in order, Mr. Chairman, I would make a motion for deficiency of 902 KAR 2211E as is appropriate under 13A030.
Thank you, Senator West. There has been a motion made to find KAR 002-211E deficient. The motion has been made. Is there a second to that motion? There has been a second made to that motion. Is there any discussion on that motion? There being no discussion on that motion, the question now is on the motion that has been given to us and seconded to find KAR 002-211E deficient. Those in favor of finding this regulation deficient, will vote aye. And those opposed to finding this regulation deficient will vote no. And it does take 5 yay votes in favor of this motion to find this motion deficient. So at this time, this will be a roll call vote, and I'm going to ask for the roll call vote to begin at this time.
Senator,
excuse me, but does anybody have any questions? I want to make sure everybody understands the motion and what the vote either is yes or no. A yay vote would be to find the regulation deficient on this specific one. A no vote would not find it deficient. Any questions? I'm sorry, I didn't mean to interrupt, but please go right ahead and proceed now.
Senator Rocky Adams.
Aye.
Senator Kerr.
Aye.
Senator Yates. Senator West.
Aye.
Representative Bridges.
Aye.
Representative Frazier.
Aye.
Representative Marzian. Representative Hale.
Aye.
The motion carries.
The roll call shows 6. The roll call shows 6 members voting aye and 0 members voting no. Having had 5+ members, the motion passes to find this specific regulation deficient, and it is passed. We will now, at this point, go back to the order that we were in, and please proceed with the next regulation.
Office of Health Data and Analysis, Kentucky Health Benefit Exchange, 900 KAR 10, 111, 115, 120, 125, and 130. 120 through 130 have staff suggested amendments, and 120 additionally has an agency amendment.
900 KR 10111 establishes definitions for 900 KR Chapter 10. 900 KR 10115 establishes policies and procedures relating to the certification of a qualified health plan or qualified standalone dental plan to be offered on the Kentucky Health Benefit Exchange. 900 KR 10120 establishes policies and procedures relating to eligibility and enrollment in a qualified health plan in the individual market, the operation of a small business health options program, and the formal review process for SHOP on the exchange. 900 KR 10125 establishes requirements for the Kentucky Health Benefit Exchange Consumer Assistance Program, connector certification, and individual agent participation within the exchange. 900 KR 10130 establishes policies and procedures relating to appeals of eligibility determinations for benefit exchange participation and insurance affordability programs on the exchange. 900 KR 10111 and 115 are okay without further amendment. The staff amendments for 10, 120, 125, and 130 all amend various sections to comply with KRS Chapter 13A. The agency amendment for 10, 120 amends Section 2 to provide that an employer may be notified of an employee's eligibility for an advanced payments of premium tax credit in accordance with federal law.
Thank you. Would you please identify yourself for the record on these specific regulations that was presented to us?
Yes, Carrie Banahan, Deputy Secretary, Cabinet for Health and Family Services.
Edith Sloan, Director, Health Benefit Exchange.
David Very, Staff Assistant for Kentucky Health Benefit Exchange. Sorry.
Malia Rivera, Health Benefit Exchange. Kelly Rodman, Office of Legislative Regulatory Affairs.
Good morning to you, each one of you. Thank you for being with us this morning. There are staff amendments to these regulations. Is there a motion for approval of the staff amendments? Is there a motion?
Motion.
There is a motion. Is there a second? There is a second. Without objection, it is so ordered, and there is also an agency amendment to these regulations. Is there any discussion on the agency amendment? There is Senator West. Go right ahead, sir.
Thank you. I would ask that the Cabinet explain the agency amendment.
Leon, you want to talk about the,
We changed the language from shall to may because we no longer require employers to make this notification, but we may in the future. It's consistent with what the federal guidelines are and what the CMS practice is.
Thank you.
Thank you, sir. Any further discussion on the agency amendment? Is there a motion for approval of the agency amendment?
Motion.
There is a motion. There is a second. Without objection, it is so ordered. Are there any questions on this specific regulation as amended from the members of the subcommittee? Senator West.
Thank you, Mr. Chairman. I think I'm the Cabinet's new favorite person today. Full of questions as usual.
Sure.
My questions really do not pertain necessarily to the regs that are before us. I'll warn you, these are general questions. Okay.
Okay.
So, just brief us. Where does the statutory authority come from for the health benefit exchange?
So we do have the statutory authority, I'm sorry, under, is it?
194.
Yeah, 194A, KRS 194A. 199, I'm sorry. 194A 99, so.
99, okay, thank you.
Yeah.
And where does the funding come from to carry out the mission of the benefit exchange?
So we have an assessment on health insurers called the Kentucky Access Assessment. We've had this around for years. It previously funded our high-risk pool, known as Kentucky Access, as well as our state-based exchange operations on the federal platform. So it's a 1% assessment on the premium for large employer groups, small employer groups, association plans, and individual market plans.
And so, with the previous administration, Bevan administration, more or less did away with the exchange, and I guess opted for the federal exchange. Am I correct in that?
You are correct, yes.
Okay. And when the new administration came in under Governor Beshear, we more or less went back to the model previously in place before Governor Bevan's administration. Is that correct?
Well, yeah, that's what we're transitioning to.
Right.
Yes.
We're attempting to get there, is what you're...
Correct. That is correct, yes.
Gotcha. So the reason for my line of questioning is I thought specifically, and I could be wrong, I thought specifically when we were in Appropriations and Revenue Committee that we put in budget language that did not allow for this, that mandated that we stay the course, that the funding continue within the federal exchange model, and that we do not go back to the health benefit exchange. Is that correct or incorrect?
That is incorrect. I'm not aware of any language, in a budget bill or currently in statute that would prevent the establishment of our state-based exchange. That side, KRS 194-99, it gives us broad authority to implement the provisions of the Affordable Care Act. And one of the provisions of the Affordable Care Act is to establish a state-based exchange.
And full disclosure, that was a question that I warned you.
Certainly, I understand. I understand.
My memory is waning some days, so it's possible.
Yeah.
So does it cost the state money to operate this exchange? Let's say we stuck with the federal exchange and didn't operate the new health benefit exchange, I guess how many additional dollars is it costing us to put back in place this new exchange, exchange that was there before?
Right. So it's going to actually cost us, an increase of $2 million in admin funds. So that will be funded through that Kentucky Access Assessment. With the federal exchange, there was a user fee of around 3% that was charged to Kentuckians. And the latest data we have on that is for plan year 2019. So Kentuckians ended up paying like an additional $15.2 million just to be on the federal exchange, in addition to the Kentucky Access Assessment that was charged as well. So with the transition to the state-based exchange, we're not going to charge that user fee. But, they will be subject to the Kentucky Access Assessment of up to 1%.
So your point is that it's costing the state more money. It's costing the state around $2 million. But we, in your estimation, we will be saving the citizenry $15 to $20 million in user fees to be on the federal exchange.
Correct, which is will be reflected in reduced premiums for Kentuckians. Yes.
That's all my questions. Thank you, Mr. Chairman.
Thank you, Senator. Are there any other questions on this specific regulation as amended? There being no further questions, thank you all very much. We appreciate your time and your response to our questions. Please call the next regulation, and we have kind of gotten out of order here, but we are going to take these. We still have 2 more regulations, and we're going to do them one at a time. So please call the next regulation.
Under Department for Public Health, Maternal and Child Health, 902 KAR 4150. This has staff suggested amendment.
902-4150 establishes provisions for home visitation related to at-risk parents through teleservice in the event of a declared public health emergency. The staff suggested amendment amends Section 2 to comply with KRS Chapter 13A.
Again, would you please identify yourselves for the record at this time?
Yes, I'm Julie Brooks, Regulations Coordinator for the Department for Public Health, and I have Paula Goff with me.
Thank you, Ms. Brooks. Ms. Goff.
Paula, you're on mute.
Oh.
Sorry.
Good morning. I'm Paula Goff. I'm the branch manager for early childhood development at the Department for Public Health.
Thank you very much, Ms. Goff. There is a staff amendment on this specific regulation. Is there a motion for approval of the staff amendment?
Motion.
There is a motion. Is there a second? There is a second. Without objection, it is so ordered. Are there any questions for either of the ladies on this specific regulation? There are no further questions. Thank you, ladies, very much. Please call the next regulation.
902-3210 establishes provision for teleintervention in the event of a declared public health emergency. The staff suggested amendment amends various sections to comply with KRS Chapter 13A.
Would you please identify yourself for the record again?
Yes, I'm Julie Brooks, Regulation Coordinator for the Department for Public Health.
And I'm Paula Goff. I am the branch manager for early childhood development at the Department for Public Health.
Ladies, again, I hate to ask you that each time, but we must have that for our public record. So thank you again. There is a staff amendment. Is there a motion for approval of the staff amendment?
Motion.
There is a motion. Is there a second? There is a second. Without objection, it is so ordered. Are there any questions from the members of this subcommittee concerning this specific regulation? There being no questions, thank you, ladies, again for. I'm sorry, anyone else? Was there a question? There was no question or comment from any of the members. If there being no further questions, we thank you, ladies, and we appreciate your time today. And I think that is am I correct? That is the end of the agenda today. So we are going to find out at this point when our next meeting is.
We have it currently scheduled for July 8th. It's a Thursday at 3 p.m.
July 8th is the next scheduled meeting. Let's check schedules here just real quickly. July the 8th, 3 p.m., correct?
Yes.
July the 8th for the next meeting. We appreciate all that have joined us today, and the meeting we've had a lot of great questions and comments from the members and from those that joined us today. I appreciate you coming up and joining us and everybody being with us. I want to thank the staff. There was a lot of information that we need to have compiled for us today, and we thank you all very much for that.
Can I comment on that?
Yes, go ahead.
Well, thank you, Mr. Chairman. I'd like to reiterate that comment that there was a lot of stuff flying around the last minute, and as always, they are nimble and do a great job. So thank you.
They do a tremendous job, and we very much appreciate them. At this time, is there a motion for adjournment? There is a motion, and there is a second. Meeting adjourned.